Oh, wow. So, how are you doing? So,
Fine, and you? How are you doing?
good. How long are you
nicely.
going to be speaking?
1 hour. Not
1
more
hour,
than
good.
that.
Okay. I was trying
We're
an hour
going to
and
do
a half.
questions right after each speaker.
Oh, really?
And then we'll have some collective work.
All right, so I think we're going to go ahead and get started as people are making their way back into the room. Again, sorry about the short break. We will try to keep this panel a little bit more on track with the time so that we can enjoy our full lunch break. So I'd like to welcome all of you once again to the second panel of the day. This panel is titled The State Act of Aggression and the Security Council. So I would like to introduce General Charles Dunlap, who will be serving as the moderator for this panel. General Dunlap is a visiting professor here at Duke Law. He has extensive knowledge and experience in military and national security law. He is the former Deputy Judge Advocate General of the United States Air Force. During his service in the Air Force, he served tours in the United Kingdom and Korea, and he deployed for operations in the Middle East and Africa. He also led military-to-military delegations to Colombia, Uruguay, and the Czech Republic. Please join me in welcoming General Dunlap and the second panel.
Thank you very much for that kind invitation. And I just want to say that I am really proud to be associated with Duke and the students that put together this wonderful conference. It really is a tremendous accomplishment, having tried to put together conferences myself from time to time. I'm going to make Drew put together our conference in the spring. But I also want to say something else. It really is very refreshing to see the number of students who are attending. And as Professor Morris, I think, alluded to, it's exciting to see these young people who are really getting into international law and international affairs, because I think Professor Morris and I would agree that it really is the future, almost any part of your practice, whatever area you're focusing in on, it'll have a strong international dimension. And one other thing I want to say before I introduce our wonderful panelists. You know, one of the things I was thinking about in preparing for this and then listening to the first panel, there is so much you can learn about the practice of law on the international level just by studying how these processes work. How is it that you go about getting consensus on an international level? How is it that you build the relationships that will produce a product at the end? And also, it kind of illustrates the challenges that you have in a multicultural global environment of coming to agreement. But I think that the students can learn a lot just by looking at the process, because those processes will be valuable in, I would suggest, completely other kinds of disciplines. In any event, let me introduce our extremely qualified panel to speak about this particular aspect of the Kampala meeting. Marcelo Bohlke, did I pronounce that right?
Yes.
Is a Brazilian career diplomat currently posted in the permanent mission of Brazil to the United Nations in New York. And if you look at his biography in the materials, he really has been a facilitator and very active in the whole issue of the International Criminal Court, almost from the very beginning, because he was a facilitator of the resolutions to the Assembly of State Parties to the Rome Statute. He's been a facilitator of the review conference for the Rome Statute, and he's been one of the most important international scholars, writing and speaking about the issues associated with the International Criminal Court. It's a special pleasure to have Georgia Harley here, because she is an Australian diplomat. She was at Kampala, but she's also here at Duke. She's taken a year off as a fellow, and she is pursuing a number of different interests. And I see her frequently at almost every event that we have here at Duke, whatever the speaker's coming in, and she certainly has illustrated the value of having this kind of globalized campus right here at Duke. She served the Australian government at various international associations. She worked in the Office of International Law at the Australian Attorney General's Department. She has a Bachelor of Arts from the University of Queensland, and she will graduate from the Australian National University with a Master's LLM in International Law. And our third panelist is Frederick McGill. See, I'm very concerned about causing an international incident with my mispronunciations of someone's name, and as you might imagine, my language skills, despite being a graduate of a Jesuit university, are very poor. He's on the faculty of law at McGill University. He holds the Canada Research Chair in Law of Human Rights and Legal Pluralism, and is affiliated with the McGill Center of the same name. And what's very interesting is he's the co-editor of a forthcoming second edition of the United Nations and Human Rights. And this work focuses on international criminal justice. Now, what the subject of our panel is the state of aggression and the Security Council. Drew prepared for me some talking points, and I reviewed them. Drew, you did an excellent job. But what I think I will do this is your life in the future, Drew. Take a note. What I thought I would do is talk about Harold Coe's interpretation of what transpired at Kampala vis-a-vis the Security Council and what the role would be of the Security Council. Now, I know many of you are familiar with this, but perhaps there's one or two people in the audience who have not had a chance to read the interview that he gave in June concerning the outcome of the review conference. What he said was, talking about the crime of aggression and what the role of the Security Council would be, we all know it's effectively further decisions been put off to 2017. But what he said is that the crime of aggression couldn't become operational unless it was affirmatively adopted after another review by consensus or two-thirds decision of all state parties no earlier than January 1st, 2017. And when he talks about the way the crime could be referred, he said one channel that would go through an exclusive Security Council trigger, and a second channel which would go through a prior Security Council review subject to 4 conditions. If the Security Council did not make a determination that aggression had occurred, the prosecutor would have to offer a reasonable basis for investigating the crime under a definition that's been clarified by understandings we suggested. The prosecution would then have to get a majority vote of 6 judges of the court's pretrial division. The Security Council would still, at that point, have the authority to stop the prosecution with a red light Chapter 7 resolution, disapproving the resolution. As I said, meaning, I'm speaking as Coe would, the channel would not apply to nationals of non-state parties or any non-consenting state party who opted out. That is the way Harold Coe interpreted the role of the Security Council with respect to a state act of aggression. And I'm hopeful that we're going to have our panelists will address perhaps that or other aspects of the event in Kampala, but also their personal experience and their personal views and experiences, because I think that's what the audience would be most interested in hearing about. And if we could start with Marcelo, we're going to do it a little bit differently than based on Drew's advice, that perhaps after each speaker we'll have a short period.
Oh, we'll do it after all.
Am I no longer a general? Or? Okay, we'll do it your way, Kris. Thank you.
Wow.
I hope this is not for me. Well, thank you. Well, it's commonly said that diplomats think too much, and but I can't avoid that. So I'd like to really start by thanking, of course, Duke Law School and the Duke chapter of the ICC Student Network for organizing this timely event, and of course for kindly inviting me to be part of the event here today. I think that what we heard this morning was that Kampala conference was a success. We made significant achievements there. So, and I completely agree with Professor Morris that now it's time for us to try to understand exactly how we're going to implement the decisions that were made in Kampala. And this is why the event is so timely, and I think it's a real pleasure to see here so many people that had an active participation in the negotiations and in the final outcome. Well, in my presentation, I'll try to address what I consider one of the key points in our negotiations, which was to try to understand the role of the Security Council as the body that is primarily responsible for the maintenance of international peace and security, vis-a-vis the role of the ICC in considering situations relating to the crime of aggression. So for that, I'll just initially then introduce the debate itself, the topic, and then if I have enough time, I will try to discuss a little bit on the role of the powers of the Security Council according to the UN Charter first. And then second, I'll try to analyze how the ICC works with regards to the crime of aggression and the relation between the ICC and the UN, especially the Security Council. That's second. And then the third point would be some insights of the negotiations related to these points. And finally, the fourth point would be on the amendments, if, of course, I have enough time for that. Otherwise, I'll be glad to comment on questions regarding these points. So, as I said, I think one of the most important or most difficult parts of the negotiation was to establish the role of the Security Council vis-a-vis the definition of the crime of aggression and the exercise of jurisdiction by the ICC over the crime of aggression. There were different views. Some delegations, mostly the P5, the 5 permanent members of the Security Council, would prefer that the court would proceed with investigations only after the Security Council has determined the existence of an act of aggression. So that is their reading of the UN Charter. Many other delegations wanted to retain the independence of the court, and they were of the view that the Security Council does not and should not have an exclusive role in terms of determination of an act of aggression. So the Security Council is primarily responsible for maintenance of international peace and security, but it's not the only body that would be entitled to determine the existence of an act of aggression. Well, on one point, it's obvious that for an individual to commit an act of aggression, there should have been, to commit a crime of aggression, there should have been an act of aggression. And the decision we reached in Kampala, and it was clearly explained this morning, was that only acts committed or acts by states would lead to a crime of aggression. So one thing is the individual responsibility for an act, another thing is the state act. And I think the definition sets this very clearly. So the Security Council, what's the role of the Security Council in this? The Security Council is responsible for the maintenance of international peace and security. So the Council determines the existence of an act of aggression and then discusses possible or desirable measures to restore or maintain international peace and security. It's not exactly in the role of the Security Council to attribute individual criminal responsibility. Of course, we know that the Security Council has already established ad hoc tribunals But that's a different debate, and we would need another event to discuss to what extent the Security Council can create international tribunals. But the different point here is that the Security Council deals with actions of states, and the ICC deals with individual criminal responsibility. Well, that's the overall topic. Now, on the Security Council, I think this morning Professor Morris also highlighted the history of the use of force, or the legal implications or the lawfulness of the use of force. We don't need to go as far as Francisco de Vitoria or Francisco Soares or Hugo Grotius, Pufendorf, and all those jurists that try to describe the just war. We just need to start probably with the Calabria Pact of 1928, in which states renounced the use of force, not the use of force, but renounced war as a national policy. And war is not exactly the same as use of force. There are some legal implications for you to qualify an act as war, including the declaration of a war. Use of force is much broader. And when we came to the period just after the Second World War, there was a clear concern that there would be a third devastating war. So the idea, the main goal, was to avoid that from happening. So that's why in the UN Charter, you see that one of the purposes of the organization is to maintain international peace and security, and to take effective collective measures for the suppression of acts of aggression. That was considered one of the main purposes, if not the main purpose, of the organization. How could that purpose be achieved? And then some principles were set in Article 2 of the UN Charter, including the famous Article 2, Paragraph 4, in which states accept the obligation to refrain from the threat or use of force against another state. This article has been debated for a long time, and there was even an article in the 1970s in which Professor Thomas Frank, denounced the death of Article 2, Paragraph 4, saying that it's not valid anymore. It was established for an organization that did not develop the way it was expected. But this is it's a difficult comment to make, because Article 2, Paragraph 4 is the foundation of the UN Charter, is the foundation of also the stable international system. And this is because the UN Charter completely outlawed the use of force. So it's not that states renounce war as a way to pursue political or national policies. Now, in the UN Charter, there is a complete prohibition on the use of force. We would even would not be inaccurate to say that there is a use contra bellum now, and not a use ad bellum. There are, of course, exceptions that the UN Charter accepted. And one of them, and both of them, in fact, are in Chapter 7. One of them is when the Security Council authorizes and gives a specific mandate for the use of force. This has already been addressed. And the second one is in Article 51 of the UN Charter, which deals with self-defense. And of course, the interpretation of these provisions have been also subject to discussions. We heard here some debates about humanitarian intervention, about anticipatory self-defense, preemptive self-defense. All these issues, in fact, were dealt or should have been dealt with at the UN Charter. So when you see, for example, the conditions or the exceptions on the prohibition of the use of force, they're very clear. And Article 51, when it refers to self-defense, it refers to the inherent or natural right to self-defense if an armed attack occurs. So the language is very precise. In order to pursue the goals or the purposes of the United Nations, the Security Council was then entrusted with a lot of powers as its primary responsibility for the maintenance of international peace and security. And states accepted the obligation to fulfill the decisions or to carry out the decisions made by the Security Council. Now, On the powers more specifically of the Security Council, the Security Council can determine if an act of aggression or threat to peace or breach of peace has happened, and then take further decisions. But what has happened since the creation of the United Nations? The Security Council has, in very few cases, addressed or determined that an act of aggression has occurred. In my recollection, there are 5 countries or 5 situations mostly that were referred to as acts of, or examples of acts of aggression. For example, the first one was in southern Rhodesia, the current territory of Zimbabwe, on acts of aggression committed against their neighbors in the 70s. After that, it was again in the 70s, beginning of the 80s, regarding South Africa during the apartheid regime, and also again on acts of aggression committed against their southern African neighbors. After that, in 1977, the Security Council decided that the invading force of mercenaries against Benin was an act of aggression. In the mid and late 80s, the Security Council determined that acts of Israel against Tunisia were also acts of aggression. And finally, in the beginning of the 90s, 1990, there was this case of Iraq, the invasion of Iraq in the territory of Kuwait. And in that case, it's interesting because the Security Council did not determine that an act of aggression had occurred. The Security Council just stated that the invasion was unlawful, so an unlawful occupation. So this is not exactly a determination that an act of aggression had occurred, but of course the language signaled that there was an act of aggression. Now, turning to the second point on the jurisdiction of the court. We know that Article 5 lists all the crimes that are within the jurisdiction of the court. And one of those 4 crimes is a crime of aggression. Of course, there was a compromise deal in Rome in 1998, which was to include the crime of aggression in the list of crimes, but then the exercise of jurisdiction would only be done after the definition. There is the adoption of a definition of the crime of aggression and a decision on the conditions for the exercise of jurisdiction. There was never a question about whether the court should or should not have jurisdiction over the crime of aggression, because that decision was made in Rome. So for those who fear that, who wanted to bring this discussion back into the Kampala process, the common answer was, well, that debate was held in Rome in 1998. Now it's time for us to decide on the definition and on the conditions for the exercise of jurisdiction. It was also very common to hear some delegations saying that if the court pursued this avenue and tried to adjudicate cases relating to the crime of aggression, it would interfere with the work of the Security Council. And of course, that was already set in Rome. In the preamble, for example, of the Rome Statute, it says that the most serious crimes of international concern threaten the peace, security, and well-being of the world. Everyone understands that it's not only the crime of aggression, but also war crimes and international crimes against humanity and genocide that can threaten the peace and security. So the role of the ICC vis-a-vis the Security Council is much more of a complementary nature and should not be seen as one body interfering with the work of the other. I would even say that the work of the ICC is a contribution to the maintenance of international peace and security by strengthening the rule of law at the international level. Everyone understands that, of course, there is a clear link between the ICC and the UN. That's why they even have a cooperation agreement. And if you read through the Rome Statute, you'll find many provisions that refer to the Security Council. For example, if you go to Article 13b, you'll see that the Security Council may refer situations to the ICC. And this is what happened, for example, with the case concerning Darfur. I remember it was a very tough discussion on this in March 2005. And Brazil was in the presidency of the Security Council, and on the very last day, The very last day of our presidency in March, there was this endless debate whether the Security Council should refer the situation to the court or not. The final decision was to refer. So that's an expression of interaction between the two bodies. Article 16, that's a more polemic, let's say, provision, but it also deals with interaction between the Security Council and the ICC, when it states that no investigation or prosecution may be commenced or proceeded with for a period of 12 months after the Security Council has requested to that effect, using a Chapter 7 resolution. So the Security Council can suspend an investigation for 12 months. Of course, that suspension, that request can be renewed under the same conditions. So that's another form of interaction, or formal interaction between the two bodies. Now, very quickly on the negotiations. I'll just jump some parts here, skip some parts, and go to these discussions on Security Council in relation to the ICC. As you know, there are 3 trigger mechanisms for the jurisdiction of the court. So a state party can refer a situation, the Security Council can refer a situation, or the prosecutor can start investigations pro motu. That's clear. But when we were discussing the crime of aggression, there was varying levels of support to each of these trigger mechanisms for the crime of aggression. That's why I think the coordinator of our discussions now in March decided to convene a roll call. And he used 2 different elements. One was the interest of states in the necessity that the Security Council has made a prior determination on an act of aggression so that the court can exercise its jurisdiction. So is it a necessity or not? That was one of the elements. And the second, is it required the consent of the aggressor state so that the court can proceed with investigations? And bear in mind these 2 questions. The coordinator decided to formulate 4 options. Option 1. Option 1 is both of them have to be answered yes, which means, yes, the Security Council has to have made a prior determination that an act of aggression has occurred. And yes, the aggressor state needs to express its consent to the jurisdiction of the court. The second option was, no, just the Security Council determination is enough. The third option was, no, just the consent of the aggressor state is enough. And option 4, none of those, or neither of these options, which means that it's not required the Security Council determination and it's not required the consent of the aggressor state. Well, what was the result? Around 75% of delegations opted for options 3 and 4, which means no Security Council involvement. And few delegations opted for 2, and some delegations opted for 1. So it just gives us some idea on how the delegations viewed the participation of the Security Council in the work of the court. Now, and it leads me to my final point, which was then on the amendments. So take into consideration these views and the difficulties some delegations had with pro motu investigations and state party referral regarding crime of aggression. Some delegations, including my own and Argentina and Switzerland, tried to devise a new way to incorporate these different perceptions into a workable package deal or compromise deal. And our idea was to try to set very easy conditions for the Security Council to refer situations to the ICC. It seems that it was not a big problem for the Security Council to refer situations, but it was a big problem or it was a problem in terms of state party referrals and or investigations pro motu, especially if there is no involvement of the Security Council. So the conditions for the Security Council referral would be under 121.5, which would mean just one ratification would be enough, and it would enter into force. And for the most difficult parts, let's say, we would use 121.4, which means that it would require high level of ratification, 7/8, but then it would enter into force to all delegations. There was a long debate whether it was possible under the provisions of the statute or not. But in fact, if you read the provisions in Article 121, you'll see that the language is rather vague. And it was the result of a long political process, a negotiation that took place in Rome. And it would be feasible, politically feasible and legally possible to pursue that avenue. But then there was still some more debates in Kampala, and we finally then decided to use this approach, but on a different situation. When we have now Article 15 bis, which refers to state party referrals and investigations proprio motu, and 15 ter, which refers to the Security Council referral. And they have different conditions, let's say, but they were adopted under the same provision. And our final decision was, as states parties to the Rome Statute, was that the crime of aggression is already within the jurisdiction of the court. All states parties have already accepted the jurisdiction of the court regarding those 4 crimes. And this is clear also in Articles 5 and 12. So now the amendments we adopted 7 amendments. They, once they enter into force after 2017 and the ratification of, and the deposit of 30 instruments of ratification, they will be applicable to all states parties because they have already accepted the jurisdiction of the court. If a state party does not wish to be subject to the jurisdiction of the court regarding that crime, an exception was made, which was that state could come up and formally request to be out. So that's a possibility, that's an exception that was made to the crime of aggression. That package deal gathered consensual support. So all delegations accepted these provisions or these understandings. And there was even the firm engagement of many non-states parties that participated actively in the discussions and contributed to this result, because this package deal reflects not only the views of states parties, but also of plenty of non-states parties that participate in the event. So if I may just then conclude, I'd just like to say that these 7 amendments, the elements of crime, the 7 understandings that were adopted in Kampala represent a significant achievement. Not only for the ICC, but I really believe that it's an achievement for the development of international law, for the maintenance of international peace and security, and of course for the promotion of international justice. The Security Council still has its primary responsibility for the maintenance of international peace and security and decisions on measures to restore or maintain peace. And the ICC is an independent body whose work is based on legal concepts, not political ones, and it will still be able to proceed and fulfill its obligations as stated in the Rome Statute. And of course the work of both institutions are, in my view, mutually reinforcing, and of course they contribute to the wider sense of peace and justice. Thank you.
Who's next? Georgia?
Sure.
We're going in the diplomatic alphabetical order.
Thank you, Professor Dunlap. I might start with the usual caveat that I speak today in my personal capacity. My views do not necessarily reflect those of the Australian government. The views I express are my own. Marcelo was correct in noting that this topic that we're discussing this morning on the issue of a state act of aggression and the role of the Security Council really goes to the relationship between the ICC and the Security Council with respect to this particular amendment. And Marcelo has been very gracious in going through the issues that the negotiators faced. We heard further this morning about the role of the special working group in nutting through many of those options, chasing many rabbits down burrows, and working through many of the legal and technical issues relating to how that relationship can function in practice. And then, naturally, the special working group could only go so far. It had to be referred back to a political body and be subject to the big set plays of multilateral negotiation. And so we arrive in Kampala. Marcelo has gone through with us some of the challenges that we faced. Some of the ones that I found particularly interesting were that dichotomy or the distinction between the state act of aggression, which is a question of state responsibility under international law, vis-a-vis the question of individual criminal responsibility, which is the jurisdiction of the court. And then a second interesting challenge was the relationship between, how do you reconcile the relationship between the Security Council as a political body vis-a-vis the ICC as a legal body with respect to an issue that goes so closely to state conduct and is often contentious in international relations. And then this third issue of assuming you can overcome those hurdles, and I believe that you can, and we did, that how do you then sequence procedurally, how do you coordinate the information flows and the procedural aspects of the amendment? So what I propose to do over the next few minutes, and I don't wish to take too much time because I think I'm more interested in those in the more interactive question and answer session, but is simply to go through how those many issues and challenges were resolved on the text of the amendment. So I'd start first by looking at Article 8 bis, and so the definition and the elements. And as discussed this morning, it was made clear that there had been some contention as to whether it really was possible to separate a state act of aggression versus an individual crime of aggression, and that is ultimately resolved in the definition and the elements, where in particular element 3 refers to the state act of aggression being a constituent element of the individual crime of aggression. In order to reach that individual criminal responsibility, you require those further elements so that it be manifest by its character, gravity and scale, as well as a range of a high high threshold of knowledge, factual circumstances relating to the manifest violation, etc., etc. So a series of further elements that take it from an individual, from a state act of aggression to an individual crime of aggression. That is resolved in the document now, and I think that reflects the overall jurisdiction of the International Criminal Court, which is focused on those matters of most serious concern to the international community, and taking outside small-scale violations, manifest, etc., that were discussed earlier this morning. The second interesting aspect that is resolved in the document is this question of what do we refer to? With non-prejudiciability, I think was the term that Jutta referred to. In both Article 15 bis and in Article 15 ter, it is clear that the determination of other bodies outside the court is without prejudice to the determination of the ICC. And this was to try to resolve that issue of many people saying, well, what happens if the Security Council makes one determination and the International Criminal Court makes another? Doesn't that make a farce and undermine the integrity of the Rome Statute system, etc., etc.? I mean, it's not unknown for there to be such conflicts, and there have been such conflicts between the International Court of Justice and the Security Council, and perhaps the situation of armed conflict in the Congo, as well as Bosnia and Herzegovina in the early 90s, showed that there were resolutions between UNGA, the Security Council and the ICJ that did not all neatly match up, and international law did not collapse as we know it. So this idea that one is without prejudice to the other sought to resolve that conflict. And I think that also reflects the jurisprudence of the International Court of Justice, where in the Nicaragua decision and in other decisions they have referred to the possibility that various international bodies can exercise separate but complementary functions with respect to the same substantive events. So I think that is now resolved in the document. The question then of sequencing, and I might just go through Article 15 ter and then Article 15 bis. 15 ter just because it's the easiest one, and also in the shortness of time, it's the one that doesn't get a lot of attention. I think there's a tendency to think that 15 bis, and because it is the more progressive area of the statute, is the more sort of sexy area. But I find Article 15 ter a very interesting one. What it does is provide a fully independent function for the prosecutor. I wouldn't have been personally surprised if the more conservative end of the negotiators had insisted that following a Security Council referral that it then come back to the Security Council for a further determination of an act of aggression before proceeding with indictment. But it didn't proceed that way. So what we have in Article 15 ter is the ability of the Security Council to refer matters to the International Criminal Court in a similar vein as to how it occurs for all the other crimes under the statute. So that does not require the Security Council to make a determination of an act of aggression. And as we know, there has been considerable reluctance to use there hasn't been as much reluctance to use the term aggression, but there has been some reluctance to use the term determination of an act of aggression. There has been a tendency to determine a threat to international peace and security as sufficient to enliven Chapter 7 powers. So this potentially averts the need for the Security Council to have to make that determination. It can simply pass the ball to the International Criminal Court prosecutor, and then the International Criminal Court prosecutor embarks on the normal process, conducts its investigation. If there's a reasonable basis to conclude that a crime within the jurisdiction of the court has been committed, then you go through the pretrial chamber, everything else. So that just runs the normal way, a fully independent process for the court. It averts the need for competing determinations, and thereby, I think, reduces the risk of a perception of conflict. Then turning to, and I think 15 ter is perhaps the less likely to be used, and I'm happy to discuss further some of the implications of what that might mean for referring situations that include several crimes, etc., etc. Perhaps we can get to that in the question and answer session. Then referring to Article 15 bis, which is the more progressive and more complex area, what we have is that the prosecutor may, in all cases, conduct a preliminary analysis, and that includes some pretty broad powers to consider whether crimes within the jurisdiction have occurred, to interview witnesses, to call hearings, to request information from states, etc., etc. But before commencing a full investigation, the prosecutor must first consider whether the Security Council has made a prior determination of an act of aggression. If the Security Council has not done so, then the prosecutor may ask the Security Council to do so, including providing the relevant information that formed the basis of the initial assessment. It's then for the Security Council to consider, but if following 6 months the Security Council has not made such a determination, then it is a question for the prosecutor to go to the pretrial to the pretrial division of the International Criminal Court for it to make a determination. So how does 15 bis resolve some of the challenges and issues? Well, first, it respects that primary role of the Security Council without insisting on an exclusive role for the Security Council, and is thus consistent with Articles 24 and 39 of the UN Charter. And in particular, I think it reflects well and positively upon that provision in, I think it's Article 24, that refers to the Security Council having a primary responsibility for a purpose, and that purpose being in order to ensure prompt and effective action, which was noted by the International Court of Justice in the certain expenses case. So that is then consistent with the Charter. It's a compromise position, a consensus-based position that enables the existence of a workable regime without the insistence on pure exclusivity of the Security Council. It also respects the role of the prosecutor in ensuring that sequencing of events does not confuse their respective mandates. So I'm conscious that 15 bis has its fuzzy edges, and perhaps Marcelo and I take a different view on the interpretation of Article 121.5, but perhaps that's a discussion for the next panel in relation to entry into force and consent to amendments. But I think Article 15 bis does clarify that distinction between state act and individual act and respects the respective mandates. Then finally, the amendment retains Article 16 intact. So it continues to operate in the same way as it would for all of the other crimes within the statute. So at any juncture, the Security Council may suspend ICC proceedings with respect to the crime of aggression. Now, notably, the Security Council has not done so. It's considered that this would be a fairly rare occurrence and quite difficult to achieve, partly because as a Chapter 7 resolution it would require a majority decision of the Council as well as the absence of any exercise of veto. And it's also something that, that requires continual the continual passage of a Security Council resolution annually. So it's a difficult task to achieve once. It's a very difficult task to achieve every year. And it's also notable there that with respect to Article 16, that does not divest the International Criminal Court of jurisdiction over the crime of aggression. It's perhaps analogous to a domestic temporary stay of proceedings in the sense that the ICC continues to have jurisdiction but is not able to exercise that jurisdiction during the temporal period in which that Security Council resolution is enlivened. So that's how, what I've tried to do here is essentially try to ground some of the many interesting issues and processes that we've discussed this morning into the text of the document to then form the basis of a more interactive question and answer session. And I look forward to hearing from you.
Frederick?
All right, great. Well, first, I'm very grateful for the invitation. I'd wanted to visit Duke for a long time, so this was my opportunity. I will try to use only 10 minutes. So I kept it to 2 sheets. That's my solution to keep it short. Yeah, it was,
he'd be court-martialed otherwise.
Yeah, exactly. So let me know when I'm getting close to the time. I wasn't in Kampala. I did have the pleasure of being in Rome a little earlier. So I suppose I've been first a bit jealous of those who went to Kampala, but it sounds like it was a fantastic opportunity, and it's reminded me of these days in Rome and the sort of the complexity, the sort of the multi-level of these negotiations, how difficult it is to see a coherent position emerge until the end, how everything is up in the air sometimes until, you know, classically midnight, you know, and then the bell rings and then someone comes up with a text, not quite like that, but that's testimony to how, you know, these things are also about political will and about a particular meeting of minds on some of these issues. So I'm going to try not to repeat what Marcelo and Georgia said, but just to set the stage a little, I suppose the starting point is there's already a role for the Security Council in relation to the International Criminal Court. So this is part of a broader debate. This isn't simply about aggression being in the UN Charter. It's also about a recognition that the Security Council, the management of international peace and security, all of that has something to do with international criminal justice, although we may disagree exactly what. So really the question is not whether the Security Council should have a role in relation to the ICC when it comes to aggression, but whether that role should be notably different than what it is already for the other crimes. Okay, and so, you know, the only justification for a different role when it comes to aggression is that there's something specific, unique about that crime that warrants arguably more deference to the Security Council. And we've already heard that sort of a classic main point, I suppose, is that it's in the Charter, and it's probably in the Charter for a reason, although there's really a debate as to whether the Security Council's powers in relation to aggression are exclusive. It doesn't say they're exclusive, whether they're merely primary, or whether they're just there, and other, you know, bodies can also do international peace and security, because it doesn't say that they can't, and that's, I think, also a possibility. Now, the second specificity of aggression, and I'm not quite sure what to make of that, but it is relevant, and we haven't mentioned it so much, perhaps because we're dealing with aggression in the context of international criminal justice, and so we're interested in individuals, is, of course, aggression is the only crime that occurs between 2 states, right? Even though we won't be punishing states in the context of the ICC, this is really the background. Now, does that because there's this interstate dimension that's more sort of classic in terms of international law, should there be more of a role for a supranational body, a sort of a more Westphalian type body, such as the Security Council? That's also a possibility. Now, I've read the Kampala agreement, like all of us here, and I guess my sense is it's almost as if, I mean, I suppose if you were very idealistic about this in the first place, and thinking of the court should be totally independent, and then, it's a judicial function to determine whether aggression occurred, and let the Security Council do what it wants, but that's really its problem, then you might be disappointed by the outcome, right? You might think, oh, but you actually have to notify the Security Council. You have now, but if you come at it from a sort of realist, more traditional point of view, the Security Council is there, it's got the authority of the Charter, it's the P5, it's where things are in a sense really happening, etc. Then you might be surprised by how much sort of international criminal justice has gotten away with, right? but you might say, wow, how did this happen, right? So that's my point. It's not a normative judgment. But I'm noticing, okay, so you have to tell the Security Council, but, and great, the Security Council would probably know, this issue. It has ways of finding out these things, I'm sure, okay? So, I mean, okay, I'm simplifying here, but I don't think that there's a huge amount of deferral to the Security Council. And in fact, what I get from all of this is that we've moved on tremendously in the past, 10, 20 years, and how, it's almost, I mean, I haven't done any research on this, but, what are the permanent members who are not parties to the Rome Statute saying? Like, what are China, you probably know better than I do, what are China and Russia saying? That they're sort of, this thing is going on separately from the UN Charter, it's just like different club, and they're deciding how they're going to relate to the Security Council and what the Security Council can and can't do, which is intriguing constitutionally, right? Because it's, and I'm sure there's some people in the P5 who think, yeah, we let them say what they want, if we want to, we can, 6 months, we can extend that. I mean, you could, I'm not saying they would, I'm not saying it's politically realistic, but, there is a sense of this kind of stealthy sort of constitutional sort of charter reform, which is interesting. Anyhow, it's a classic compromise, and I'm sure it goes well for the future, and that in fact it doesn't seem to be that many protests from the Security Council, so that's interesting. Now, what I want to do very briefly is contextualize this in the evolution of both international criminal justice and the evolution of the Security Council. It's a very interesting story of a relationship that has been very cozy at times, and then, they've sort of each gone their separate way, and then they reconcile, and then, and so it starts from international criminal justice. I mean, in the early 90s, who is needy? Who sort of, who needs the Security Council? It's international criminal justice. To an extent, the Security Council figures with the ICTY and the ICTR. It can also use international criminal tribunals for its own ends. But the starting point for me is that if your plan, you're a normative entrepreneur in the early 90s, your ultimate goal is to set up permanent institutions of international criminal justice, you need to go where the power is, right? You don't do anything without power. So you naturally converge towards the Security Council. And you see, people who are pushing for the creation of the ICTY and the ICTR at the time were very much the ones saying, no, we don't want a General Assembly creation. That's sweet, but it won't really get us very far. And no, we probably wouldn't want to do a treaty. We want the Security Council, right? So there's this, it's worth remembering that it's international criminal justice that sought that attention in the first place. But of course, it was a bit of a marriage of convenience. Things sort of soon soured a little, and for sort of those who are very pro-international criminal justice realized that enlisting the Security Council's help to do this came at a cost, and we know the cost. The Security Council is notoriously fickle, right, in terms of its commitment to international criminal justice is a bit instrumental. It's not very passionate. It's a bit lukewarm, and it has huge costs for international criminal justice. The ad hocism, the essential instrumentalism, right, of international criminal justice in that context. But it's not that the Security Council wants international criminal tribunals in and for themselves. It's because it's good for reestablishing international peace and security in the former Yugoslavia. What's implied is if it wasn't, we'd move on, and the Security Council did, right? The Security Council wasn't very faithful to even its own tribunals, right? Let alone other courts that were then created separately from it. So the temptation, of course, is you want to gravitate away from the Security Council to be more like yourself, to rediscover your vocation as international criminal justice, to not have this sort of conflicting pressure of international peace and security, and you do that through the Rome Statute, right? And so but of course, that also comes at a cost. Now you're on your own, you're doing your international, your ideal international criminal institution, in a sense, but you lose the effectiveness, right? I mean, you lose the power. Now you really are on your own. You don't even have a Security Council. I mean, God knows the Security Council wasn't always helpful with the ICTY and ICTR, but at least it was there. It was this sort of, vague sort of pseudo-sovereign threat in the background. There's a bit of force involved, right? Now you don't really have that. You can, Assembly of State Parties, can meet and adopt resolutions, but that's, not necessarily the same thing. So there's that. So that's the big dilemma. And of course, I think it's just rekindled by this whole issue of aggression, that you want the referrals, you want the Security Council's business in a sense, right? So it's great if the Security Council refers the situation of aggression because that comes with added legitimacy, etc. And you're willing to do a few things to get that business. In exchange, of course, with the referrals come deferrals, right? The Security Council is saying, okay, I'll help you every now and then, but let me not help you when I need to. Now. So that's the strategic issue, the sort of the underlying policy dilemma. But there's also a constitutional problem, and that's linked to the sort of a clear overlap between aggression as defined now in the ICC and the Security Council's own mandate. And this is a big issue, right? It's an issue it's a macro, issue of reformation of the international legal landscape. I mean, really what we're trying to do is to have sort of permanent institutions of criminal justice in an international system that was traditionally not at all receptive and that's that needs to make way for these institutions, not particularly keen on making way for them. So there's really an element of struggle there. Now, I think the question is, what's the regime that dictates how that relationship is organized in last analysis, right? I mean, a lot of this is down to politics and what you can get away with and what you can what concessions you obtain, etc. But we do have the UN Charter. The UN Charter, Article 103 tells us that it's a commitment that takes precedence over all others. Okay, so any subgroup of states that is not the entire UN membership that decides to do something still has to, by and large, abide with the terms of that overall instrument. And I think there's a deep logic to this, right? That the Charter is the default system and the default institutional arrangements for an international community that is what it is, that is improvable, etc. But this is the best document that we have. If you want to go faster, if you want to progress, if you want to, as a subgroup within the international community, to upgrade your ability to punish certain crimes, etc., there's nothing in the Charter that says that that you can't do that. But I think the one condition is you have to do it in a way that's sensitive to that sort of a fallback system. Okay? So now, the only problem is all of this is moving all the time, and we don't really know what the Security Council's core role, core mission is. And so what I propose to do in the last 5 minutes is suggest 4 ways in which we can think of the role of the Security Council. Maybe I'm done.
No. Actually, your time on target is perfect.
Okay, okay.
You do have
Good,
5 minutes.
good. All right, so 4 roles. And as you know, so I'm coming at this from maybe to change the angle a little from thinking about the Security Council and its role, rather than simply thinking from a point of view of international criminal justice and seeing how the Security Council can adapt. Security Council is, of course, a complex body, and here are the 4 roles. So the 4 roles is the Security Council can be seen as a policeman, it can be seen as an adjudicator, it can be seen as a legislator, and it can be seen as an executive. I think all these roles in various ways have been suggested as likely candidates for the Council. Okay, so the first one is the idea that the Security Council is just, at least for the purposes of international criminal justice, is a police force. It's there merely to implement things that have been decided elsewhere, and that we know has never been true even of probably of the ad hoc tribunals. If it's been true of any, it's been true of the ad hoc tribunals. But as you know, the Kasese or the president of the ICTY would go to the Security Council, and the Security Council, because Karadzic still hadn't been arrested, and the Security Council would say we'd think about it. But simply because we created you doesn't mean that we, think that at every junction, international peace and security are being threatened, and we're going to give you the support you need. And now, in the case of the ICC, there's no real prospect of the Security Council doing its kind of execution work for it, its enforcement work for it. It might, but only because it serves the Security Council interests, not because the ICC asks it to do so. The second role, the extreme opposite, is to see it's a sort of very virtuous Security Council that acts as a sort of adjudicator. And in the context of aggression, that would make a sort of authoritative determination, or at least authoritative determination that aggression has been committed. And I know that the Council has done that at times, right? It's done that in relation to when creating the international criminal tribunals, for example, that it says the tribunal created to judge the grave violations of the Geneva Conventions and the crimes against humanity and the genocide that occurred in Rwanda over former Yugoslavia. So, and it doesn't just say, the resolution that creates the tribunal doesn't just say, noting the possibility still to be determined and confirmed by the ICTY so as not to prejudge the rights of the accused that genocide may have been committed. No, it happened. It's, as far as we're concerned, it happened, right? So that's adjudicatory. Now, I'd just like to note that this idea that the Security Council would be an adjudicator, which might seem quite shocking to us today. I mean, it's not a court. There's absolutely no chance for the state that's incriminated to defend itself, etc. Might seem very shocking, but there's a time when this was quite popular, and this was in the international law commissions. It seems like a century ago. The international law commissions articles on state responsibility, especially the debates in the 80s and 90s on the possibility for crime of state. At the time, if you go back to the 80s, the sort of Rip Hagen reports, and I still echo with some of you, had this idea that if a state committed a crime, then we needed the Security Council had a crucial role in responding to that crime and in sort of offering a collective response to that crime. And so we really wanted the Security Council to be a responsible Security Council and to call aggression when it saw it, and so to make it more And that was seen, by the way, as an improvement on states making these determinations themselves, right? Which was the traditional position in international law, you know, the dédoublement fonctionnel position. Each state will sort of enforce international law by knowing when it's being violated against it. The improvement there was to sort of collectivize this. Now, of course, the problem is the Council hasn't really shown, this was all very theoretical, the Security Council hasn't really shown that it wanted to live up to that potential. And it would have helped if it had, right? If it had been more sort of adjudicatory, but we know, of course, of all the many cases where aggression probably had occurred and it was, you know, the Security Council never described it as such, etc. There's all kinds of reasons for us to be a little skeptical of a Security Council on the long term, and rather than just opportunistically with certain situations describing, you know, assessing that certain crimes have been committed. And there's, of course, a fair trial issue. And I mentioned this, the accused before the ICTY and the ICTR were the first to pick up on this. It's a very easy argument in a sense. It was given to them, well, you know, the title of a tribunal seems to assume something that has yet to be proved, which is that, you know, genocide was actually committed. Of course, the tribunal say, no, no, we're not bound by our name, etc. But it's a bit of a hard sell. So I'll skip one. No, I will. Okay, the Council is a legislator. So I'm down to half a minute. The Council.
Circling.
Okay, so the Council is legislator. Okay, the important thing is that the Security Council historically has really made it possible for international criminal justice to exist in certain circumstances where it wouldn't have existed otherwise, and it may go on to do so, and that's one reason to want to have good relations with the Security Council. The ad hoc tribunals, I mentioned them, but of course the possibility of referrals, and for example, the Darfur referral, a huge bonus for international criminal justice, right? I mean, because the court wasn't created, you know, for, I don't know, Denmark to be prosecuted, right? I mean, there's this eternal problem that the states you would want to be in the court are generally going to know better and you know, figure this out before they get in. So you need the Security Council to bridge that gap and to give you jurisdiction over, you know, via Chapter 7, via threats to international peace and security over states that wouldn't have agreed to it. So I think that's something that the ICC should be able to live with. And if it means that the security, it has to give something in return, like notifying the Security Council, maybe that's not a bad thing. And the final role is the Security Council as an executive. And there is, of course, the possibility that if the Security Council does not want to be a legislator, it doesn't want to be an adjudicator, although it doesn't want to be the police either, it just wants to be an executive that's doing something that's fundamentally different from what international criminal justice is doing. So the two can coexist in sort of benign indifference to each other, okay? And here the example I came up with is just imagine the Security Council is a riot police, okay? The riot police deals with instant threats, right? And a mob violence, a demonstration that goes wrong, etc. In the process of quelling a riot, it has to make an exercise of administrative discretion that this is indeed what's happening, and presumably there'll be guidelines, right? So it's proto-legal, right? You don't just go in there and define anything as a riot. But at the same time, domestically, the fact that the police, you know, had to intervene because they felt there was a breach of peace wouldn't bind the courts at all afterwards. It would just operate at a totally different level. It wouldn't even be introduced as such in evidence, right? Their judgment that something was amiss or something there was a breach of peace wouldn't be conclusive at all. And so, you know, I think there really is a sense that if we see the Security Council's role as akin to that of a riot police, the fact that it has determined that there's a threat to international peace and security, that even there's, for operational purposes, and something such as aggression shouldn't really bind the court at all, and in fact that's, you know, I think the reason why in the end the Kampala consensus tells us that the court will not be bound by the determinations of any other body. Sorry for abusing your patience.
Before inviting the comment of our expert commentators, I want to exercise the prerogative, if it's okay with Kris and Drew, to exercise the prerogative of the moderator and open it to questions from students only. Does any student have a question?
I hope I'm doing this right. I'm from UNC, so we don't have microphones in our desk. I'm very interested in, I guess, looking at some hypotheticals. Certainly comparing sort of political posturing now to the future with respect to the Security Council. Just the other day, President Obama spoke about endorsing India's right to join the permanent members of the Security Council. Our colleague from Brazil probably has his own thoughts about his country's right to join the permanent members. Japan comes to mind, of course. In the future, should there be a change made to the permanent member composition, and you can pick and choose which country you want to add, certainly it changes the political posturing. But how are we going to see the interplay of the Security Council change with respect to the ICC in the future? I mean, the aggression, since it doesn't come into effect until at least 2017, the Security Council might be changed by then. So I just am very curious about some sort of the operative as opposed to the theoretical hypotheticals.
In order to maximize the number of questions, let's limit our top-of-the-head responses to this one to 30 seconds. Yes, I want the kingdom of Dunlap to be, permanent. But other than that.
Well, why don't you collect questions first, and then maybe we can
expand
this 30 seconds.
Because I'm the general. This is the way I want it.
All right.
I'm happy to commence if you'd like. It's true that the negotiations did become a lightning rod for Security Council reform issues, and the opportunity for many states parties, non-parties, NGOs, etc., to either express dissatisfaction with the membership or with the perceived selectivity of previous Security Council practice. And from my perspective, we knew that would happen, but it was not necessarily a helpful contribution to the question of the crime of aggression and the role of the statute, because the statute is a full body of self-contained material, and it is intended to be without prejudice to the Security Council and other issues. So I take your point. I don't intend to conjecture as to what might occur if India or if the balance of P2 vis-a-vis P5 changes. I don't think that any of us are in a position to know that, but I think the key issue is that for those that have dissatisfaction, the appropriate channel for that are those issues of Security Council reform rather than attacking the individual crime of aggression, which has a very narrow focus and which is already contained within the statute and which has been resolved to some extent pending 2017 in Kampala. So to the extent that there are questions about how the Security Council should function, they are questions for the Security Council, and I don't think that the ICC or the Assembly of States Parties is necessarily the appropriate avenue for airing all of that.
Thank you, Georgia.
I'll pass. If I may. Well, maybe I should have done just like Georgia at the beginning and say that these are my personal views.
I'm a conservative.
Not necessarily reflect the views of my government. But I think our friend here has touched on a very, very important issue. And the issue of the Security Council reform has been long overdue. I think everyone understands that the configuration of power in 1945 is not exactly the configuration of power today, and so this has had some heavy costs, I think, in terms of legitimacy and effectiveness of the Security Council, and I think everyone agrees on that. There are different views as to how the Security Council should be reformed, who should be in, and the different configurations. And I think I would suggest you read, for example, an article published this week by The Economist, thinking the unthinkable. And it reflects now this renewed energy or interest in the reform of the Security Council. And I think it's widely understood that a Security Council should be representative of the world configuration of, in terms of power, to be more legitimate. Now, what does it have to do with the discussions we had in the crime of aggression? Maybe not. I think most of the discussions we had, even though some delegations, I must say, some delegations stressed that they did not want a stronger participation or interference of the Security Council because the Security Council has been losing power or effectiveness or legitimacy along the way, so they would not like the Security Council to be more involved in this. These arguments, in fact, were stated during the negotiations. But in my view, this is not exactly intertwined. They're not intertwined.
Thank you very much, Marcelo.
Okay.
Any other questions from student? One more, Justin?
Yeah, I'm Justin Bart. I'm a student here at Duke. I have a question specifically for Mr. McGray. You touched on briefly the sort of present and past relationship between the ICC and the Security Council. And I'm wondering, also looking forward, do you think it would be most beneficial for the court, particularly with in terms of the crime of aggression, to sort of increase and deepen the relationship between the court and the Security Council? Or do you think that ultimately, especially in light of Mr. Kress's remarks last night about sort of the uniform application of the law in terms of legitimacy of the court and not having the Security Council countries being insulated from prosecution, do you think it's ultimately in the best interest of the crime and the court to distance itself from the Security Council?
It's a very tricky question. I think, all right, so pros of enlisting the help of the Security Council. I mean, I think one of them is, of course, the fact that the ICC has a much more restricted jurisdictional reach under aggression than it does for other crimes, since it can only prosecute aggression if the crime was committed by nationals on the territory of two states that are both parties, right? Which is not the same situation as for the other crimes. I think that's an added argument why you would want Security Council support in these cases. I don't see that there's. I'm inclined to think that a rapprochement and getting closer to the council overall is not a bad thing. There's the council itself, as you know, is moving in a direction where it's more cooperative. The low point was definitely the resolutions that excluded jurisdiction over peacekeepers and with related threats of pulling out of peacekeeper by one country of pulling out of Bosnia. And so I think the relationship in that respect has been sort of started to be mended since. And there's a sense in which the Security Council might also think that this is in its interest. I mean, that, you know, the court is there, it's ready to be used, certainly more practical than creating an ad hoc tribunal. It might also confer on the Security Council a certain legitimacy, that it sees its work not simply as the traditional international peace and security sort, but increasingly as being one cog in a sort of complex system of enforcement of international law. But yeah, we'll see what happens.
Any other commentators? Let's open it up for one more question from the general audience. Then I'm going to ask the expert commentators to do a 2-minute drill, and then we'll 2-minute drill each, and we'll get more or less back on schedule. Professor Mars, did you have a question?
My name is Lena Siraj. I'm a student at Duke Law School. I'm actually more interested in situations in which, well, like you said before, the Security Council has been very selective in what situations to call a crime of aggression, and the ones that they have has been a definitive state acting against another state. I was more interested in situations where it was not that definitive. Take the situation in Kashmir, where it's disputed territory, and the Security Council has decreed disputed territory, and there isn't a clear aggressive
So there's a lot in there. I mean, one thing is the Security Council has been central in redefining what constitutes a threat to international peace and security, and almost what constitutes aggression, and in particular has been has been part of a movement that has extended the qualifier for aggression to situations where a non-state actor attacks another state, but with the agreement or the support of a state. So I think the Security Council could refer situations that are not clearly aggression. Merely, the advantage is it can refer them merely because they constitute threats to international peace and security, right, or breaches. It doesn't have to be aggression. And that potentially opens up whole areas of the world to the court's jurisdiction. And that's it, sorry. So there are many parts to your question, but...
Okay, our expert commentators.
Sorry.
Oh, sorry.
On that question of allegations or perceptions of selectivity by the Security Council, I take the point, and I think it's to some extent a valid one, but I think it's worthwhile not to simply pick on the Security Council, but to review across the board the various bodies that do have some role in considering acts of aggression. And I'd highlight that the General Assembly has also been reluctant to designate aggression. They have in a couple more cases, and in particular I'm thinking of Bosnia-Herzegovina and I think Israel in the Golan Heights, and there's probably been a couple of others that I can't recall off the top of my head. But in very many cases has refrained from doing so when called upon. And similarly, the International Court of Justice has been given stellar opportunities to identify aggression, but also has refrained from using the A word. And I think the most remarkable example of that was in the armed activities in the DRC, where it was specifically a pleaded act of aggression, and the court came back with grave violations of the prohibition under Article 2.4. Not sure now what that means vis-a-vis aggression given this context. So I think it's very easy to pick on the Security Council and say, oh, they're selective and they're not representative. But you look to a more representative body like the UNGA, and they've not necessarily done so in more circumstances. You look to a purely legal body like the ICJ, they've been reluctant to. So I think that goes to a question of what we're talking about, and going back to what Klaus was referring to before, this is an inherently very narrow crime. Very, very limited scope of applicability, very limited number of individuals that would fall within its scope. So there are, thankfully, I think very few examples of acts of aggression since World War II. And among them you'd probably indicate perhaps Korea, perhaps Czechoslovakia, Iraq, Kuwait, and I can't really think of many more. So on that question of selectivity, I think that is to some extent a misnomer, but it's an easy shot to make. Then on the question of what would play out, it wouldn't play out, I think is the answer. The International Criminal Court prosecutor has to date assiduously avoided politicisation and has focused its attention on mass atrocities in Africa, which is really what we're more often than not talking about here. If you look at the Security Council agenda, it's all fragile states in Africa. I don't think it would proceed. My personal view is it wouldn't proceed beyond a preliminary analysis, let alone to anything else. And there are so many safeguards in the definition, in the elements, in the conditions for jurisdiction, in the entry into force provisions and everything else that would prevent a situation where there was ambiguity from coming before the court. I think the criticism that it therefore wouldn't include Kashmir is perhaps a valid one. That should go elsewhere. It's not a function of the International Criminal Court. If anything, the criticism here should be that we've created perhaps such a narrow crime that I think my colleague Gary Simpson refers to it as only referring to crazy dictator cases. So in attempt to answer to your question, I think perhaps, again, channeling the energy of those issues into other fora that is not really a question of the ICC.
Thank you, Georgia. And finally, and in conclusion.
Very, very quickly. So Frederick's remarks, it's not whether the Security Council shall have a role. I guess all of this is driven, of course, by Article 39 of the Charter. The Security Council shall determine a threat to the peace, breach of the peace, act of aggression. And this is what is driving all of this, because it tells us immediately aggression is somewhat different from all of our other ICC crimes. The Security Council is going to play a role. It can't have a binding role that would destroy the presumption of innocence, but it can stop investigations. Why? It's not something really necessarily driven here. First, it was decided at Rome the Security Council would have this role when it created Article 16, but it was arguably necessary to give the Security Council a role to make it consistent with the Charter, with under 103 of the Charter to recognize its Article 39 role. There were those at Kampala that said the Security Council should have really the only significant role, two strong voices. But many, many voices said that destroys the court's independence. There were the vast bulk of the states said no, the Security Council should not have this role. The ICC needs to be protected. It needs to be independent. But then we were concerned, well, how is this reconciled with Article 39 of the Charter? What would it mean to lose the Security Council's support to act against all of the P5 states? So I think the compromise result, which maybe left neither basket completely happy, is quite brilliant because it encompasses both. The Security Council has first crack at the apple, it maintains its role, but then there can be the International Criminal Court acting as its own filter. Just one other quick reflection is when Marcelo was mentioning all these resolutions, or a few resolutions, where the Security Council determines there's an act of aggression, you know, it is essentially giving a thumbs up or thumbs down based on a political debate and of tremendous significance, whether there will be peacekeepers committed, etc. Massive power. It has no requirement that it act consistently. It doesn't have to look at jurisprudence. It doesn't need to look at any of the case law that will be developed. So the notion here is we're taking this out of the political realm to some extent and putting it in a judicial realm where there will be a body that will use jurisprudence. It will look at precedent, and it will try to harmonize. So some ways, I think it's much more scary at the Security Council level to have this kind of thumbs up, thumbs down adjudicatory power over this crime. And then just one tiny final reflection. You know, we adjudicate whether something is genocide, and our statutory language is it intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. That's it. That is the question of genocide. Now, there's underlying crimes, but that is our core. That is the core of it. It is so much less. And it's not disputed at all that the courts can do this. They've developed a body of precedent. There's tremendous precedent on genocide, war crimes, crimes against humanity. Well, that at one point didn't exist. So maybe you're uncomfortable. Well, we don't have this precedent fully yet. No, we don't. And at one point, the tribunals didn't either. The first ICTR, ICTY cases, they're trying to use Nuremberg, they're trying to use ICJ. They have very little to go on. You know, by now we take it for granted that there is this great body of case law that they can use. In the case of aggression, it will need to be developed in the case of a crime of aggression. So we shouldn't be dismayed that we don't have a perfect definition of manifest. At one point, it was not clear what is widespread, what is systematic, what is intent to destroy. That is what judges do.
Thank you. Sebastian?
Even quicker. So, Marcelo, I'm not sure I agree with the 1-2-1-4, 1-2-1-5 interaction, but maybe we can talk about that over lunch. I did talk to you about it in Kampala as well. But what I was going to ask is, you said that there was consensus in the room for the ABS proposal, which was really clever in many ways. I still have a copy of it. For those of you who weren't there, you should know that it was clever not only because it was trying to build this compromise position around sort of a time delay of the different jurisdictional triggers, but also because it was a chart, and so it was kind of a, you know, trying something new at the time when the negotiations were stalling. So it was interesting. But anyway, so you said there was consensus for this position. I mean, my recollection, and you would know better, but my recollection was that the Japanese were definitely had a different legal position on 1215 and 1214. There was also the Canadian counter-proposal, which they then withdrew. So I want to know a little bit more about what that consensus was and how also it evolved towards the later compromise proposal. And for Georgia, you alluded to this, and I'm very interested in this issue. So 13 ter in the ICC statute allows the Security Council to refer a situation. The resolution that's adopted says that 13 ter will be subject to what's in this resolution, and it refers to the referral of a crime of aggression. So I'm curious as to, and as we know, as some of you may know, in the case of the state referral of Uganda, the prosecutor took he's taken a wide position on the concept of referral, which is that a state can't just refer the other party. So in the case of Uganda, Uganda tried to sort of basically refer the LRA to the ICC, but the prosecutor said, no, I'm going to look at everything, and including the conduct of the government of Uganda. So I'm curious, on the one hand, do you think that the crime of that the resolution restricts the scope of this referral of a situation, that the Security Council for the crime of aggression can only refer a crime of aggression as opposed to a situation? And secondly, again, in the language there is the crime of aggression, I think, by a state that's... So the question is, can the prosecutor also take a wider stance and say, well, you've referred the crime of aggression by this one state, but I'm also going to look at the possibility, well, I guess it's kind of convoluted, but the possibility that there might have been another crime of aggression related to that one. So that would be the sort of...
Well, I think we have Sebastian's given us a lot of things to talk about over lunch, so we can stay on schedule. And I want to throw out another question that people can talk about over lunch, and maybe I'm just acting out of my own ignorance. But what Dean Coe described as the role of the Security Council with respect to the crime of aggression that I mentioned, that I read from earlier, I would like to know if people think that's a cogent summary or a problematic oversimplification, because as you might imagine in this country, that will be a hot button issue, if not today, in 2017. I'd like to thank our panelists. They did a terrific job, and for an academic conference, they were very timely,
Well, I would definitely like to thank General Dunlap for keeping us in such good time during this panel. Very amazing, very impressive.
Despite the coordination.
And again, thanking the panelists and our commentators and our audience members for your excellent questions. At this time, we will take a break for lunch. We'll have a little over an hour for lunch. We'll be serving it in the Star Commons. To reach the Star Commons, if you're not familiar with our building, you exit this room and turn right, go down to the end of the hall, and there's a